initiation of a criminal proceeding. So that is an arrest, obviously. If we do not authorize it by law, then it will be illegal and won't serve the purpose. So, through this legislation, such an arrest by a private person has been authorized. But again, a private person is a private person, just like us, with our own whims and fancies, with our own weaknesses, and with the liberties that we enjoy. So, there is a need to curb his powers of arrest as well, and that to more than a police officer. So this section is also very detailed in respect of the fact that it tells you what are the pieces, what are the situations, what are the offences in which a private arrest can be made, and how is it to be made. Then there is an arrest by magistrate. If someone commits an offence in the presence of magistrate, that person who wields the sovereign power in this country, could he be just expected to sit and call police or wait for the police to come? No, perhaps that is too absurd and illogical. So this code also gives power to a magistrate to effect an arrest of an accused who has committed crime in the presence of a magistrate. Now, what happens after arrest? So that is the next logical flow that comes in this chapter. It says after arrest, it now comes the process of how arrest is to be made. So like there is whether by touching a person or like just ensuring that he feels himself to be obliged under law to be in the custody for the initiation of criminal proceedings. All those things can be classified as arrest within the provisions of this code. Apart from that, in the modus operandi of arrest, this code also provides as to how to pursue offenders in other jurisdictions. So there are guidelines in respect of that as well, because this is an imminent possibility. If we have seen the movie Dawn, which I am quite impressed of, Shah Rukh Khan's, we know that where there are criminals involved in organized crimes who might just go to other jurisdictions. So I don't know honestly what is there in this provision. Perhaps some of you would like read it and discuss with me on some day. But yeah, it does talk about it. It does mention us that eventuality in this legislation. So this legislation is super cool. It takes care of almost everything. That's why it is a code. And then it says no unnecessary restraint to be exercised while effecting an arrest. Something very contradictory. Unnecessary restraint. There is no need for an unnecessary restraint while effecting an arrest. So that is something which we should take note of, because that is quite contradictory to our daily life logic, because what we read in newspapers is police excesses being committed. So this legislation does not allow it, at least, and so as members of a legal aid clinic, you must be aware of this and be able to advise people as to how they can guard themselves against it. So this may be a ground that you might suggest someday before a court of law to save a person who has been subjected to unnecessary restraint in respect of arrest. Now what happens after an arrest is made? So this is then it talks about search of arrested persons. The search of arrested persons is something which is quite logical, because obviously that is required for collecting evidence, some sort of evidence to prove the case. So there is the search of arrested persons. Then comes the power to seize offensive weapons, because if a person is having some offensive weapon, obviously that needs to be seized, and that would happen after arrest. So it talks about what is the power, what are the contours of the power to seize offensive weapons. Then there is a very important. There are two provisions here, which talk about the medical examination of the accused. At one point it says medical examination of the accused. At another point it says medical examination of the arrested persons. So while I was reading this code, a question came into my mind as to why obviously most of the time an arrested person would be an accused, or an accused person would be an arrested person unless he is on bail. So the question is, why two separate provisions? So we get a little bit clue from it itself. It says examination of accused by medical practitioner at the request of police officer. This is section 53, and section 54 says examination of arrested person by medical officer. There is a section 53A also. For your knowledge, it's examination of person accused of rape by medical practitioner. That is only, I believe, an extension of section 53. So why is there a difference between these two provisions? Could anyone guess it out? examination of accused by a medical practitioner at the request of the police officer, and examination of the arrested person by a medical practitioner, by a medical officer, sorry. So anybody who could just guess as to why such distinction has been made.
The police officer deems fit in this particular case that a medical certificate is required, then he can take the
Right for a rape victim. A medical examination needs to be conducted and on command of
like if somebody is caught with contraband substance and it is
maybe like when at the initial stage when it is done by the police officer and the medical examinations are being, maybe at that stage it's for taking charges or something, and for the second stage it's for presenting evidences when the and like we present the report for part of the experts.
They use the term accused and arrested person, so they can be different people.
See, your answer suggests to me that this class is still not out of its mindset. You are very compassionate to the victim, but not compassionate to the accused.
Maybe because of self-injury.
Yeah. Now you took a cue from my sentence, but still you're not making the answers.
In the first section, it talks about it is upon the reasonable ground a suspicion on the part of police officer whether it is or not that the person should be examined. The decision talks about the arrested person himself taking a request to pause the examination. This might lead to some evidence.
You were quite near to it, so now I'll not permit anyone to answer, and I will answer it myself. So the answer is this, that an accused, in section 53, when it talks about examination, the accused at the request of the police officer, there's a logical conclusion that that is for the collection of evidence. Very true. Many of us pointed out towards that fact itself. But when we talk about examination of arrested person by a medical officer, the word arrested person has been used because there is an element of human rights of the accused there. If a police has committed atrocities on a person, that arrested person will need evidence to prove that atrocities have been committed on me. Therefore, he will need medical examination of himself. So this legislation empowers that accused to have himself medically examined, so that if there are any atrocities committed on him, that fact gets before the court. This purpose is not written in this provision, but if you read it, you will get to it logically. You will get to it just like you will understand it by yourself if you read both the provisions together, 53 and 54. So that was about what happens after arrest. There was such. Okay, like I wasn't clear. What I am saying is that when in section 53 you talk about medical examination at the request of the police officer, it's about collection of evidence to prove his guilt. However, when in section 54 you're talking about the medical examination of an accused by a medical officer, it's about looking at as to whether any injury marks are there on his body or not. And perhaps that injury could be attributed to a police officer as well. It doesn't specifically talk about it.
It specifically talks about the police empowering the police officer to build his case, and the report talks about the arrested person to build his own case. Because any evidence
yeah, even that is a good point. Yeah, even that is a good point. I didn't think about it, but he has pointed a very good thing. There might be a case of police atrocities as well, and there might be a case where the accused might want to build up his defense. I think that's what you're trying. And I think that's a very valid statement that you made. So there is that reason. So at the end of the day, what I wanted to convey was that is for the benefit of the accused. So that is still there, and section 53 is for the benefit of the investigating agency or the police as such. Now then after that we come to since apprehensions or arrest is also called apprehensions. So when this is a very serious matter, and the executive magistrate or the district magistrate should have information as to how many apprehensions have been made, because the power of arrest is to be exercised very cautiously and very judiciously. So there is a provision that police is to report apprehensions to the district magistrate, which is there under section 58, and then it also says that although the arrest is to be exercised judiciously, discharge of a person from arrest should also be done with due caution. Therefore, it says the discharge of person apprehended under section 59 will only happen if there is a bail or a bond of security executed to that effect. So without that, you cannot discharge a person who is arrested. So that is provided there in section 59. And the last section 60A says arrest to be made strictly according to this code. So it reinforces the fact that arrest is to be made in view of the guidelines that are there in this legislation, that is CrPC. Arrest has always been a very controversial affair in this country because the police excesses that are there, and therefore I'd like to give you the name of a case which is a very landmark in this respect. DK Basu versus State of West Bengal. It lays down all the guidelines in respect of arrests to be made, and it also talks about legal aid organizations there. So if you happen to read that judgment, you might just want to search for legal aid there again, because that's important in respect of the role that a legal aid organization, just like a legal aid team that we have, could perform in respect of arrest procedures that happen in this country. After that, we come to processes to compel appearance. Basically, arrest is also a process to compel appearance in a court of law. But that is not the only process. Because as Malvin sir was saying that, as I was again repeating it, arrest is not the only mode to compel a person to come to the court. It's not a punishment, as he said very rightly. And that is to be, at the sake of repetition, I would still say that it is to be borne in mind always that arrest is not a punishment. So what are the other modes to compel appearances?
Summons.
Yeah. So there is a summons, and warrant is of the arrest only. So, but the thing is again that we do understand that arrest can be made by a police officer without a warrant. And which kind of case is that? Cognizable. So you knew that. I need not like. That's why I didn't talk about cognizable. So it's cognizable offences where arrest can be made without a warrant, and where a warrant is required. That is a court under judicial supervision. That will be non-cognizable offence, and therefore provisions as to warrant of arrest is also made there. A warrant of arrest has to be sufficiently detailed so that the person who is being arrested knows as to on which account he is being arrested, for what reason he is being arrested. Therefore, there is a host of provisions in this legislation which talk about the warrant of arrest. Then there are provisions as to proclamation and attachment, which are not very important. They are important, obviously. They are part of this code, but not very important from this class point of view. Then after that, we come to processes to compel the production of things. Just like a person can be arrested, similarly, a person can be compelled to produce things. Again, there is a constitutional logic behind it, why such provisions are there. You have a reasonable right to privacy. Although that might be contested today in Supreme Court in view of the changed circumstances, but yes, there is a reasonable right of privacy in this country available to everyone, and that cannot be infringed except in accordance with procedures established by Article 21 of the Constitution, which you always need to take in mind. Article 20 is the most pertinent provision of the Constitution in relation to your criminal justice system. So everything that happens which interferes with your life and personal liberty should be in accordance with the procedures established by law, which should be a due, fair and reasonable process after the Menka Gandhi judgment. So again, if your things have to be searched, if your home has to be searched, if a place has to be searched, it can only happen through a specific procedure, and that procedure is provided in chapter 7. That is the processes to compel the production of things. You could be issued a summons, okay, produce the thing yourself, or there could be a search warrant, so that the investigating agency is authorized to go and search the thing which is there in, which is to be searched and brought to the court. So that is about chapter 7, processes to compel the production of things. Then come chapter 7A. See, I might be talking about provisions in such a manner that is not provided in any textbook, because a textbook always categorizes, a textbook of criminal procedure will always categorize things in such a manner that they always talk about after arrest will come to investigation. But I am not doing that thing. I am just talking about what each chapter provides, so that you have an idea as to what each chapter provides in this particular legislation. So chapter 7A says reciprocal arrangements for assistance in certain matters and procedure for attachment and forfeiture of property. This reciprocal arrangement, this word reciprocal will help you to understand what is the mandate of this chapter. Chapter 7A says that we have some agreements with countries in respect of things which may be found there and which may be required by a court of law in India. So just a brief idea, these provisions are to be resorted to by the investigating agencies in respect of procuring such things to be brought before a court of law in India. So I'm not very well aware of the provisions under this head. So you might want to go and read it, cross-check it with my description, and if I'm mistaken, you can just remind me. But if I'm not, and you have read in detail about it, you could just stop me anywhere in the college and discuss with me about it. I would be very happy to know what is there in these provisions. So then comes chapter 8. Now, before I talk about chapter 8, I'd like to group it with chapter 10 and chapter 11. I'll skip chapter 9 here because that's not strictly related to what chapter 8, 10 and 11 are. See, to understand the import of provisions in chapter 8, 10 and 11, it's very important to understand that a criminal justice system should not wait for things to happen, for wrong things to happen. There should be a reasonable power conferred upon the investigating agencies, the courts that are established under this procedure, and other offices to prevent wrong things from happening. So how will that happen? Yeah, that is a thing. That is a very important thing. But preventive detention is sometimes considered as very antithetical to the constitutional values of a country. Although it is allowed in our constitution, it's still a very controversial kind of a topic. But there are some things which could be done not so controversially, and still bad things could be avoided. Because detention is again a kind of infringement of a liberty, which should not be resorted to until and unless required in extreme circumstances. Therefore, there is a provision in the Constitution in respect of preventive detention. So you can understand how serious that thing is. You cannot resort to preventive detention every time. So you have धारा 144 जो लगती है, तो वो इसी preventive action के अंदर आती है. Section 144. I think that is the most that's the jargon that is used in Hindi. That's why I just used it. So there is, I won't talk about it in detail, but chapter 8 talks about security for keeping the peace and for good behavior. So there is provisions under this chapter that the court may compel you to give security, so that you guarantee the court that okay, I won't indulge in bad behavior and I would cooperate with the system to maintain peace. So see the kind of security that could be taken. There is security for keeping the peace on conviction. So if you are convicted, you will still keep peace, you have to pay security for it. Security for keeping the peace in other cases. Security for good behavior from persons disseminating seditious matters. This is the problem with our country. Most of the people would most of the times be talking about seditious matters in this country, and therefore this provision is very much required. Then security for good behavior from suspected persons. So if you are a suspected person, again you could be subjected to the machinery of this code for preventive action. Then there is security for good behavior from habitual offenders. क्लास में जो थोड़ा सा ज़्यादा हरकतें करते हैं उनसे कहा जाता है कि अगली बार तमीज़ से रहना. So यही you could understand it with respect to this. If you are a habitual offender, it's मेरी नजरें तो ऊपर हैं हमेशा. So that is how the law ensures in CrPC this thing. And if you are not able to do the security, there is a provision for imprisonment in default of security. But I do believe there may be conditions for it. So you might just go to this provision. That's section 122, imprisonment in default of security, to see what are the conditions which imprisonment could be effected. And then after chapter 8, there is chapter 10, which talks about maintenance of public order and tranquility. That is about unlawful assemblies, dispersal of unlawful assemblies. Unlawful assemblies are defined in IPC. So if there is an unlawful assembly, before it commits something wrong, like a riot, which is an offence under the IPC, the investigating agency should have the power to disperse an unlawful assembly. Even under this code, the army has that power. So all those provisions are there here. Then public nuisance, which you might have heard about in torts. You might have heard about private nuisance in torts. So this is public nuisance. So for public nuisance, contrary to the torts law, we have legislative provisions, very clear legislative provisions. So that is there. And then disputes as to immovable property. Immovable property is a very sensitive matter for people in India, because first of all, it takes a lot of years to resolve a property dispute when you will be learning about property law, your teacher would certainly tell you about the real position in this country. The position is very pathetic, starting to the point of registration of property, and therefore most of the disputes arise because of this. If you have seen the movie Khosla Bhosla, you will realize how painful it is for someone to lose his property. That is a recommended movie. I must say, before studying property law, you must watch that movie at least once. Even if you have seen it, therefore. So, and it's also recommended by Sudeep sir, so it's not my recommendation. So, when there is a dispute of immovable property and it has the potential to cause violence in the society, our legislature has been very cautious about it and has made provisions so that those things could be averted, and therefore you might have to appear before court. The court will decide who will have the possession of the property for the time being, irrespective of the outcome of your case in a civil proceeding, because property right is a matter of civil proceeding, and therefore that is something that you all might want to, and there is a provision which you might want to read before studying property law. So I must recommend that you study it once.
Like the property held by Waqf board and different shrine boards would be under provision.
See, I told you don't ask me questions. Because now you are learning. And that will be the very end of my lecture. But I'll definitely get an answer to you. Please tell me your question. I'll just go today and I'll search for it. What's your question? No, you just tell me. See, I'm not, honestly, I'm not in a position to answer it now, but you should tell me the question. I did not know it. Please.
Besides this provision, the property held by Waqf boards and different shrine boards are under the input of this provision.
See, as per the provision in this particular legislation, I don't think any exclusion has been made in respect of that. But I need to go through the Waqf Act to understand whether they have made some provision or not, because a Waqf legislation would be a special legislation in respect of this. So if they have made some provision, I am not aware of that. So I definitely get back to you when I read it. So I'll make it a point to read about it too. So that's the thing. After that, we come to the preventive action of the police. So the earlier provisions were about where executive magistrates most of the time are taking preventive actions. But there are also preventive actions which can be taken by the police, and it's very important to define this ambit because police has a lot of parts, and their parts should be restricted to a concentrated extent. So how they can take a preventive action is in detail provided here. I hope you would like to study the further provisions, or would you like to just go?
Further.
If anybody wants to leave, he could go. Like, there is no restriction to sit in this class, because I am not taking attendance, and I am not going to come again for you to take my revenge if you leave this class. So that's for sure. You could just bang out of this class anytime you want. That's the full liberty I can give you in this class. What is the question? He should not take teachers every day. He should be sitting here. Please don't take him because the camera is always functioning. I don't know whether what's audio. But that camera is it's going to be on YouTube. So that's okay. So coming back to the provisions, there are a lot of provisions. So, see, I'm just flipping through the table of contents, and it's still such a bulky legislation. It must have been a nightmare for the drafters of this legislation to come up with this. And I think it's our duty to read it as law students, because only in that manner we could give respect to the drafters of this legislation. I know that is quite a point of okay, information to the police and their powers to investigate is a very important chapter, chapter number 12. So you might want to take a note of it, because FIRs, although not named such in this legislation, are filed in section 154. So information in cognizable cases. The title to this provision reads information in cognizable cases, and section 155 talks about information as to non-cognizable cases and investigation of such cases. There is a marked difference between the procedure of investigation of both these cases, because cognizable cases are by normal logic very serious offences which need to be taken care of, and section 155 non-cognizable offences are not so serious offences, and therefore the procedure of their investigation is quite different. Then there is the police officer's part to investigate cognizable offence. I think this provision has been made. Could you take all these?